My topic is it's about the content is about two issues. The first is protection of design, and the second is enforcement of design. So as you know that it's like others definition of other country. The industrial design it's normally it's the appearance of the product and expressed in shape, line, dimension, and all the combination of thereof. So for the registering the industrial design, we have doing the formality examination and the substantive examination process. So first one is a formal examination. I didn't see the workflow here, but can you see it? Yeah, okay. For the checking the application, you we see if the application meets the requirements. If it is on the positive side, which means that it meets all requirements, so the decision of formality will be issued to the applicant. And then the Gazette publish, and it will move to the substantive examination. Or if not, then the notification of the formality of examination will be issued to the applicant and to have something to correct. And if the applicant is respond, and then it will turn back, and if not, then the decision of the application refuser will be issued. So for the application checklist, so as you know that Vietnam its law is only allow one design in one application. So for the sufficient, you have to, the applicant need to check, or the office also checking the sufficient minimum of the documentation, which means it's like, for example, like the application form or the power attorney, if the applicant is submit through the an attorney, or the document of the priority date, and the description of the design. The second one is other documents required, which means it's, for example, it's a publicly disclosure of the design about like within, of course, it should be within 6 months as according to the regulations normally. So the third one is sufficient numbers of set of photos and drawing. So for the application, it needs like to have the picture of the design, about 7 pictures, which is the first one is the front, the second one is the back, left and right, up and down, and the last one is a picture of the design itself. So it's 7 pictures, or the drawings. So the fourth one is a document that meet requirements. It's sometimes that it's like the sign of this person, or stamp, or whatever it's required for the applicant. It's a right to submit the application. And of course, the fees and charge must be fully paid. As you know that in Vietnam, we do not allow to register the partial product. And for Vietnam, we are newly applying the online platform for applicant to submit the document and also they can also pay online. Yes, and on the next one, for sometimes, as I said, it's might be the application or the design maybe need the correction, which mean here is a four issue. Is the first one is a set of the photos. So the photos or the picture of the design must be precise, clear, and of course the dimension, it should be consistent. If it is not consistent, so it will not meet the requirements. Of course, the description, it should be clear, and it's also must meet the requirements, and the subject register inconsistently between the photo drawing or the between photo and the description. And of course, the name here, the name of the design is not if it's not consistent with the declaration or the description, the applicant also need to correct. For example, here I show you the the application. For example, here is the this application is obviously does not certify the uniformity. So the first design is the pen cover. The second design is the body of the pen. So this is two separate application. So it should be put in one application actually. Here is another example. It's the application, it might not certify the consistency, but it's still satisfactory in the terms of formality, or maybe rejected in the substantive examination. Like you see, the difference of the chair is the shoulder of the chair and the handheld of the chair, armchair. Okay. And the next one is for the product label. We also protect the product label. So the application may not certify the consistency, but it's still satisfactory in terms of formality and may be rejected in the substantive examination. So what the applicant need to do is they, like if they have a box of the design or the two sides of the sachet of the product, you should spread it and put it in one picture only. So it could be correct. So the next one is for the duration of formality process. So you will see that we have 1 month after the filing date, there will be the notification of correction or decision of formality examination. And after that, they will have 2 months for correction, and then for correction. And if there is no correction, the decision formality will move to the Gazette, as I said a while ago. And for duration of Gazette, here you see that after the decision of formality examination, we will have 2 months. And of course, after that, it's a Gazette published to the third party who may have an opposition on the application. The next one is a substantive examination process. So for the substantive examination process, we will have the, of course, the design must, or the application must be meets all the requirements. And if it meets all the requirements, so it's a decision for the grant protection. And after that, the applicant need to submit some fees for grant protection, registration, and for the gazette. If during the substantive examination stage, the design does not meet the requirements, so there will be a notification for substantive. So the applicant may be correct or maybe respond to the office for this. So if there's no response, the office absolutely will issue the decision of refusal of protection. Yes. Yeah, if everything is appropriate, then of course the granting of the protection. For the next one, of course, it said in our IP law here for the Article 63, it said that the design, it should meet requirements to be new and to be creative, and must be also the susceptible of industrial application. So some other country does not have a substantive examination, but in Vietnam we do substantive examination for all the IP objects. For example, like trademark, design, patent. And the purpose of the substantive examination is to evaluate whether the industry design is stated in the application is satisfy the requirements as the terms will select or to conduct the design as it is a functional design or a design, or it is the design itself. So in this issue, we will decide of an industrial design. Industrial property stated in the application according to the protection condition to determine whether the industrial design meets the protection requirements. The determination of the scope of the protection of an industrial design in case an industrial design is granted a protection title. So can you hear me? Hello?
Yes, we do.
Yes, okay. Because I see some my internet
I
is
stopped your camera.
unstable.
Of course, I stopped your camera.
Yes,
Better sound.
Yes, yes. Okay, and next one, it's because in Vietnam we only allow one design in one application. So if there is options of the design, so we will see in the substantive examination to see if it is related design or if it's not. Then if it's not, then we will ask the applicant to split the application. So for the split application, before issuing the notification, the examiner could contact to the applicant to see if it is voluntary or he need the request of the office to make the split application. So it falls in two issues. It's like the split one or several options in a new application, or split one or several products in a product set into a new application. So here is for example of a split application. You will see two chairs, one is green and one is gray. And for the in its original application, it has the picture of these two chairs. For the option one, and they have option two. So when we ask the applicant to separate and for into application. Of course, at this time, the priority date is still kept for the applicant to have it for the split application. Another example for split application here is for the set of the product. For example, you will see the original application. It's all the set with the teapot, the cups, the milk pot, and the sugar container. They have all the same pattern. For the pattern, the drawing on the appearance. But at this time, we will ask because the sugar container here is might not be related to the sets of the tea. So we will ask them to separate the application. Another example here, it's a set of application which is, you will see the glass table and the chair. So the examiner could might think that they will not they will stand good separately. So the product could stand separately. So the examiner would ask the applicant to split the application. Of course, during the substantive examination, when search for the all relevant documents are found during the information search, and also including the third party appears if we receive from the third party. So next one is duration of formality process. So after the gazette, you will have about like 7 months for examining. So after that, after 7 months, you will have the notification of substantive examination, and then giving the applicant to 3 months to answer, or giving answer, or to make the application clear. And then after that, we have 2 months and 10 days for granting the decision. It might be protected or it might be refused. So for the protection title, the duration in our country, it's totally 15 years. It will be protected for the first 5 years, and it could be renewed twice in a row and 5 years each. So totally 15 years. And the design, it could be invalid, which is applicant. It might be applicant that does not have the right to apply, or the industrial design doesn't meet the protection requirement at the time of grant protection. And of course, self-invalidation if the right owner denied the protection. Might be because he want to apply for a new design, or maybe he could like do not renew the protection title. So after 5 years, it will invalidate. Second one, it's about the enforcement of industry design. So it's set it in our IP law. It's Article 125. It's regarding the industry design, and the author of the industry design, a person who have created the industry design object, and where more than one person to have created design, it shall be a co-owner. So So next one is about the Article 126. So we will clarify the act of infringement and of the right industry design. Here is like if the person using the industry design or the layout design without paying compensation or using protected design without the consent of the owner. Here is an infringement case. Uh, in our office, we do support the enforcement board authorities to examine or to examine the infringement. So for the evaluation method, what we do is we see and compare all the styling features of the product in shape and the dimension, the color, with a relevant design feature of the industry design protected. So in this example, you will see it's a plastic bottle of oil, lubricant oil for motorcycle. So you can see the pattern, and the yellow pattern is actually it's in the label, form of curvy strip on a white background on a product label with a logo and product information interwoven with a red arrow bar, but without a triangular strip, the black and the white checkbox style. But the above difference is that does not create design in general and is considered not to be significantly different from the design according to the design number 15727. So yeah, it's a design protected with the color. Of course, this time I did not scan the color. Uh, just take a picture black and white. Yeah, it's the use of the label. And here is you will see the one it's on the right side, it's infringer, and the first one is protected, and the left side it's protected. So regarding the IP enforcement in Vietnam, here is you will see the diagram of the workflow of the enforcement system. First one, the IP owner will discover the infringement or violation of the product or his design, and then he has to select the infringement or the violation handling measures. He could make a notification request or suspension of the infringement, warning for consequences like it's stated on the strip to the infringer. But if the infringer see it and if infringer comply, so there will be no measures needed. But if the infringer does not listen, or the right owner can go directly to the measures using directly three measures. Here we have the criminal measures, civil measures, and administrative measures. Of course, for the criminal measure, it's quite difficult, and it needs to be proposed to prosecute, and needs to investigate of the agencies, police, and need to do so many different way and to have the criminal judgment. So very few right owner taking that measures, and some right owner taking civil measures. Here they will ask to sue the infringer to the court, and the civil court will make some fee, and some go to court and take acceptance of lawsuit and for civil adjudication and civil judgment. So, however, it still take quite a long time. As far as I know, it's one case. It take about like 3 years. Um, that's very long time. But most of the right owner in Vietnam prefer the administrative procedures, measures. So uh, the right owner will submit the request to the administrative authorities and for the handling, and the agencies of administrative authorities, it might be the local people's committee, inspectorate, market management, police, or the customs for the in the border area. For the administrative authorities, they will investigate the testing, they evaluate, then they will give administrative handling decision. So the maximum of time of administrative procedure, it takes about 2 months. But the minimum times, as far as I know, it's take about like 20 to 30 days. Okay, next one here, as I mentioned, so our enforcement as administrative authorities. So all the enforcement authorities, it's established locally. So most of the suburbs, cities, district will also have these authorities so around the country. So what we do, so our IP Viet Nam, what we do is we provide the expertise opinion and assist the enforcement agencies in identifying infringement of IPR. So expert advice primarily related to the clarification of the legal status and the scope of protection of the property rights related to the enforcement activities that the agency implementing. The agencies often request the expert advice include the economic police, market surveillance, inspectorate of science and technology. Sometimes it's a competition administration department related to unfair competition. So here is some information that I would like to give you here. In 2019, our office, our division, when have given the expert opinion enforcement about 111 cases to enforcement agencies. So you will see that the patents is the 5 cases, the trademark it's 104 cases, but the design it's 2 cases. So in Vietnam, very few cases of infringement it's regarding to the design. So here you will see we separate the authorities have asked for giving the opinion. So you see the economic police is leading, and the second is market surveillance. Third is science technology inspector. So the next one is our statistics for the first 11 months, so almost complete the year. So it's updated until the 30th of November. So we have answer giving opinion about 157 cases. So here you will see the design. It's I mean like 2 cases. It's very few compared to the trademark. And the leading agencies, it's still economic police and the second one it's across market surveillance.